Today's episode tackles some of the most pressing fault lines in our criminal justice system right now. We begin with the escalating fight over court reforms and the real risk facing jury trials. We then turn to the latest developments in the Lucy Letby case, with a sharp focus on the upcoming inquests, following up from our conversation with Stephanie Davies. We then end with major new referrals from the Criminal Cases Review Commission. Stay with us until the end, as we ask a critical question: are these isolated developments, or are we witnessing the early signs of a profound shift in how justice is done?
Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today's episode tackles some of the most pressing fault lines in the criminal justice system right now. Stay with us until the end as we ask a critical question, starting with the intensifying debate over court reforms. It appears that the government's proposed jury trial slashing plan is moving ahead, despite significant criticism from across the legal and policy landscape. Among those raising concerns, as we have reported before, is the Institute for Government, which has argued that the proposed reforms are likely to deliver only modest reductions in demand, while carrying serious risks for the justice system. The Institute for Government has also pointed to a widely supported alternative. Rather than cutting back on jury trials, it argues that improving court productivity could achieve meaningful results more quickly and with far less demand. This approach, it says, enjoys broad support across the sector and could be implemented at pace. As many will be aware, the second part of Sir Brian Levison's independent review, focusing specifically on court efficiency and productivity, is due to be published in spring 2026. Now, Sir Brian has previously indicated that it does not believe modest efficiency gains alone would be sufficient to reduce the case backlog. Even so, the review is expected to clarify a number of outstanding questions and may, in our view, at least indirectly, lend support to the view that improving productivity offers a more credible route forward. Justice has also launched a campaign to oppose the current government proposal. Their campaign has three key objectives. Let's hear from Justice.
Your support will fund and make possible our targeted efforts to do three important things. Firstly, educate the public and politicians about what is really at stake when jury trials are stripped away. Not efficiency, but fairness, accountability, and trust in justice. We need to all defend the principle that justice belongs to all of us. 2, show that juries are not the cause of court delays, and that removing them will not fix a broken system, but weaken it. And 3, challenge racial discrimination in the criminal courts. Jury trials are a vital safeguard against bias. Evidence shows that Black and other minority defendants are more likely to be convicted in non-jury courts. Removing the right to trial by jury risks entrenching inequality and deepening mistrust in a system that already fails too many communities.
We hope that those opposing the current proposals will continue their efforts and succeed in presenting the robust evidence needed to demonstrate that productivity reform, rather than curtailing jury trials, is the better solution. Ideally, this would lead to the proposals being abandoned altogether, or at the very least significantly scaled back before irreversible damage is done to the jury trial system and to public confidence in the administration of justice. Turning now on the latest developments surrounding the Lucy Letby case, I wanted to start by saying a huge thank you for all your kind comments on our last week's video when we were joined by Stephanie Davies. I'm grateful for the warm and supportive welcome you gave her. Following that conversation, I'd like to share a brief follow-up and an update on the upcoming inquests, provided to me by Stephanie herself. You may recall that Stephanie explained that a number of inquests into the babies that form part of the original indictment in the Lucy Letby case were likely to be opened this week, as inquests had not originally been opened. These babies were baby E, C, I, K, O and P. Well, the Cheshire Coroner has now published a list of the babies for whom inquest will be opened this week. As Stephanie had anticipated, the list indeed includes baby C, E, I, O and P. However, baby K, who was also mentioned by Stephanie, does not appear on that list. It is not clear why that is the case, given that no inquest was originally opened for baby K and that she was the subject of a retrial which ended in a conviction. It would normally be expected that an inquest would also be opened, but this does not appear so. I must stress that we do not know why that is the case. The list on the coroner's webpage also does not mention the baby who died at Liverpool's Women's Hospital, which was originally referred to in a recent BBC article, which stated that an inquest into this baby was to be opened this week. Stephanie explained, if you remember, that this case would initially fall under the Liverpool and Wirral coroner and will then need to be transferred to the Cheshire Coroner. It is therefore unclear whether that case is not listed here simply because that transfer has not yet taken place, or whether the BBC report was inaccurate. More broadly, what also remains unclear is how the coroner will deal, or if indeed will be dealing, with the 9 other babies considered lately by the CPS, where it was decided that there was not enough evidence to bring criminal charges. We do not know whether post-mortem examinations were ever carried out in those cases, whether inquests were ever opened and posed during the investigation, or whether medical death certificates were issued and will now remain unchanged because no criminal trial will take place. We simply do not know. The lack of any new developments in these latest cases is, in some respect, disappointing. In those cases where no criminal proceedings had taken place, any inquests would have been able to examine the available material more freely. There was therefore some hope on our part that inquests might lead to further disclosure of information, which could in turn have assisted in considering a potential appeal. That does not seem to be the case. Fiona, I hope this has answered your question. But while this has not happened so far, it does not rule out the possibility of developments in the future. For now, it remains important to recognize the limit of the process and to focus only on information that has been formally confirmed. The same announcement on the coroner's page also makes clear that the inquests which will be open this week will be suspended. In simple terms, this means that there will not be public inquest hearings. Again, this is something that Stephanie had predicted. Brendan, it looks like you are right and that the CCRC application decision will come before any possible inquest. Given this announcement, I thought it would make sense to complete the picture into the coroner's inquest by looking into coroner's suspension, adjournment and resumptions of investigations and inquests, which we did not explore in our video with Stephanie. As I said, I have no experience of coroner's process, so I am relying entirely on a guidance I have found online, which I will link in the description below. In simple terms, and to summarize, but I would urge you to read the guidance for yourself, a coroner may suspend an inquest where there is another official process that needs to take priority. In particular, the guidance tells us that there are 3 circumstances in which the coroner is obliged to suspend an inquest. In other words, it must suspend the inquest. The first circumstance is on the ground that a person either has been or may be charged either with a homicide offence involving the death of the deceased or an offence alleged to be a related offence. Also, an inquest must be suspended where there is an inquiry under the Inquiries Act 2005. And finally, where the coroner is satisfied that the deceased had a relevant association with a visiting force. Now, we can certainly exclude the last circumstance in this case, but the other 2 certainly apply. First of all, the Thirlwall Inquiry's final report is still pending, so it cannot be said that it is complete. Also, although criminal proceedings have concluded, an application to the CCRC is pending, and that hopefully will give rise to an appeal. So on that basis of this guidance, it appears that the coroner's position is tight, and the only possible outcome is suspension for the time being. These may not apply to the other cases recently decided by the CPS, but as we've said, we have no further information on those yet. Now, is suspension the end of the matter, you may ask? No, the inquest is not closed. It is simply put on hold. A suspended inquest can be resumed once the reason for the suspension no longer exists. At that point, the coroner will review what still needs to be determined. The coroner may resume the inquest and hold hearings or decide that no further hearings are needed because the criminal process has already answered the key questions. Now, when does a coroner's job finish? This is known as Functus Officio, which is Latin and means that the function of the coroner is concluded. A coroner becomes Functus Officio when the inquest has been concluded and the coroner has formally recorded the cause of death and issued the necessary registration. Once this happens, the coroner no longer has legal authority to reopen or continue investigating that death. The case is in legal terms complete. There are very limited exceptions when an inquest can be reopened, such as if the higher court orders a fresh inquest, or if new and compelling evidence come to light that meets a high legal threshold. The law on when a coroner's role is considered Functus Officio was clarified in 2015 in the case of Flower and H.M. Coroner for the county of Devon, Plymouth, Torbay and South Devon. In that case, the court explained that where a coroner has paused an investigation because of criminal proceedings, and then decides not to resume it once proceedings conclude, the coroner is not Functus Officio, because no inquest has actually taken place. In simple terms, if an inquest was never held, the coroner's role is not over. More broadly, where a coroner has opened an investigation or an inquest and then either suspend it or adjourn it, the process has neither been held nor completed. That means the coroner remains legally responsible for the case and retains the power and, where appropriate, the duty to return to it if there is sufficient reason to do so. That concludes the issue of suspension and adjournment and the coroner's role. Finally, one issue that was not fully explored in last week's video is the question of compensation. Our understanding is that the route to compensation depends on the cause of death. Where a death is found to be an unlawful killing, including cases of gross negligence manslaughter, compensation may be available through the Criminal Inquiries Compensation Authority, CICA. Where a death results from poor care, families may instead have the option of bringing a civil claim through the courts. Contrary to common assumption, civil claims can sometimes result in higher compensation as there is no upper limit on damages, whereas awards through the CICA are generally capped at £500,000. Death from natural causes would not usually give rise to any compensation claim. That said, this is not an area in which we claim specialist expertise, and we would not want to risk providing inaccurate or misleading information. But in general, the new developments indicate that things are moving forward, even if slowly. While some points are now clearer, others remain unanswered. For now, we are limited to confirmed information and would encourage caution around speculation. We will continue to share updates as soon as there is anything concrete to report. Finally, a significant update from the Criminal Cases Review Commission, the CCRC. Over the past week, the Commission has made two major group referrals, one relating to IPP and DPP sentences imposed on young people, and another following the Supreme Court's decision in the Libor and Euribor cases. In this video, we reported that the CCRC announced in August 2025 that it was re-examining historic cases involving indeterminate and detention for public protection sentences, those imposed on children and young adults. These followed Court of Appeal rulings in two cases which found that sentencing judges had failed to give sufficient weight to the age and maturity of the offenders. That review, led by a specialist project group under a CCRC commissioner, has now led to tangible results. On the 27th of January 2026, the CCRC confirmed that it had referred the sentences of 5 individuals for appeal. All 5, Benjamin Hibbert, Stuart O'Neill, J. Davies, Luke Ings and James Ward, were aged between 15 and 20 at the time they received IPP or DPP sentences. Also important in the announcement, the CCRC has confirmed that it is receiving around 16 such cases each month. Currently has around 110 under review and has begun reassessing older cases that were previously rejected to determine whether recent legal developments may now apply. The Commission has also encouraged others in similar circumstances who have exhausted their appeal rights to come forward. And similarly, in this video, we discussed the Supreme Court ruling in the cases of Tom Hayes and Carlo Palombo, and the possibility that it could open the door to others convicted following similar jury misdirections. That has now happened. The CCRC has referred 5 further convictions of city traders, concluding that the same jury misdirection and legal errors identified by the Supreme Court in the cases of Tom Hayes and Carlo Palombo applied to their cases and undermined the safety of their convictions. Those referred include Alex Pabon, J.V. Merchant, Jonathan Matthew, Philippine Moryusef and Colin Birmingham, all convicted between 2016 and 2019 at Southwark Crown Court with sentences ranging from 2 to 8 years. In short, this is a rare but significant moment where recent appellate and Supreme Court rulings are translating into concrete action, reopening the door for groups of cases that may have been wrongly decided. Taken together, these developments raise an important question. Are we beginning to see a cultural shift where major institutions recognize that a justice system willing to confront and correct its own mistakes is one that ultimately earns greater public trust? The real test, however, still lies ahead. For many years, the Court of Appeal has shown a marked reluctance to place the interest of justice above strict procedural constraints. Whether that approach is now evolving remains to be seen. It is only when these cases are determined by the Court of Appeal that we will be able to judge whether this represents a genuine change in culture or whether once again early signs of progress give way to familiar resistance. On that hopeful note, it feels like the right time to bring this episode to an end. As always, please like, share and subscribe if you'd like to support our mission to humanize the criminal justice system. Join us again as we sit and rise in this unique trial.